Hello and welcome viewers, you're watching In Depth with your host Kriti, a platform where we break the most complex issues of the world and our country in just 5 simple questions and their 5 simple answers and help you understand how these issues matter to you. Minister of Law and Justice has sent a letter to the Chief Justice of India, Lalit, for sending his recommendation for appointment of his successor. So how is the Chief Justice of India appointed? Well, the Constitution of India does not mention any procedure for appointing the CJI. Article 124(1) of the Constitution merely says there shall be a Supreme Court of India consisting of a Chief Justice of India. Clause 2 of Article 124 of the Constitution says that every judge of the Supreme Court shall be appointed by the President. Thus, in the absence of a constitutional provision, the procedure to appoint CJI relies on convention. The outgoing CJI recommends his successor, a practice which is strictly based on seniority. Thus, after a CJI retires at the age of 65, the senior-most judge in the Supreme Court becomes the CJI. Seniority, however, is not defined by age, but by the number of years a judge has been serving in the top court of the country. In cases where the two judges have the same seniority, other factors like who among the two has more years of experience in the High Court, or whether any of them was nominated from the bar directly, or who took the oath first, come into play. But there have been exceptions as well, when the senior-most judge was not appointed as a CJI. Justice A.N. Ray was appointed as a CJI on April 25, 1973 by superseding 3 senior-most judges. In 1977, Justice M.H. Beg superseded Justice H.R. Khanna. So what is the Memorandum of Procedure? Well, the actual procedure to appoint the next CJI is laid out in the Memorandum of Procedure between the government and the judiciary. The MOP lays down that the appointment to the office of the Chief Justice of India should be of the senior-most judge of the Supreme Court considered fit to hold office. The Union Law Minister initiates the procedure by seeking the recommendation of the outgoing CJI at an appropriate time as per the MOP. The Law Minister puts up the recommendation to the Prime Minister, who advises the President in the matter of appointment. So what is the role of the government? Well, the central government has no role to play in the appointment of the CJI except for the Union Law Minister seeking the recommendation from the incumbent CJI before sending it to the Prime Minister. The CJI's appointment differs significantly from that of the other judges, as the government is not permitted to request a re-examination of the CJI's or the Collegium's recommendation. So what are the powers and functions of the Chief Justice of India? Well, the CJI is responsible for allocating cases and appointment of constitutional benches that deal with important matters, due to which he is often referred as the master of roster. He allocates all work to the other judges, who are bound to refer the matter back to CJI in any case where they require it to be looked into by a larger bench of more judges. CJI administers oath to President of India. CJI has the power to appoint court officials. CJI assists the President for the appointment of judges in the Supreme Court and the High Courts. CJI has the advisory powers in which CJI can instruct and advise the government to work about certain issues. CJI discharges the role of the President if the office of President and Vice President suddenly becomes vacant in emergency situations. If there is a confusion about constitutional provisions, the only valid interpretation is the one given by the Supreme Court of India. So how can the CJI be removed from the office? Well, a judge may be removed from the office through a motion adopted by Parliament on grounds of proven misbehaviour or incapacity. While the Constitution does not use the word impeachment, it is colloquially used to refer to the proceedings under Article 124 for the removal of a Supreme Court judge and Article 218 for the removal of a High Court judge. The procedure for removal of judges is elaborated in the Judges Inquiry Act of 1968. To initiate proceedings, at least 100 members of the Lok Sabha may give a signed notice to the Speaker, or at least 50 members of the Rajya Sabha may give a signed notice to the Chairman of the Upper House. The Speaker or Chairman may consult individuals and examine relevant material related to the notice. Based on this, he or she may decide to either admit the motion or refuse to admit it. If the motion is admitted, the Speaker or Chairman who receives it will constitute a 3-member committee to investigate the complaint. The motion for removal is required to be adopted by each House of Parliament by a majority of the total membership of that House and a majority of at least 2/3 of the members of that House present and voting. If the motion is adopted by this majority, the motion will be sent to the other House for adoption. Well viewers, that's all I could pack for you in this edition. Thanks for watching and stay tuned to Sansad TV. Goodbye from my side.